Okay, so we are recording. I just want to welcome everyone again. I think this is week 9 of our Thursdays at 3 webinar, and thank you to everyone last week for your patience in allowing us to postpone. Today, we are going to talk about the state of asylum. And with us, we have Eleanor Gourley, who is an attorney with CAIR Coalition's Detained Adult Program. An asylum is kind of the defense to deportation that's so commonly talked about that people know a lot about, but there's a lot to it. And so today we kind of want to demystify it, talk about the process, talk about what someone has to prove, and then go over kind of like the biggest things that are happening in asylum law in the last, year or 2 years. So Eleanor, thank you so much for being here today and taking the time to talk to me about this. Can you just start by telling us a little bit about yourself, how long you've been doing this work, etc.?
Sure. So I graduated from WashU Law School, and while there I interned for a few different public defenders' offices and also for a nonprofit immigration organization. And then after that, I went to work at the 11th Circuit Court of Appeals, which is the federal circuit court for Georgia, Florida, and Alabama. And then I came here, and that was in September 2019. So this has been where I've learned a lot about immigration and about asylum, especially working with Amma Frimpong-Hauser, who was actually in your webinar about immigration courts a few weeks ago.
Yeah, she was here a couple weeks ago. Okay, cool.
So thank you so much for having me today, talk about asylum. Before we begin, I just wanted to clarify a few things. I want to add that everything that I'm going to talk about today is defensive asylum applications. There are two ways for people to apply for asylum, affirmatively and defensively. Defensively means that the person is seeking asylum in immigration court rather than before the U.S. Citizenship and Immigration Services, also known as USCIS. And this can happen for a variety of reasons, but it often happens because the Department of Homeland Security has issued a notice to appear charging the individual as inadmissible. The person is then has to defend themselves by proving they are eligible for asylum in an adversarial context. So in a court with an attorney from the Department of Homeland Security arguing against them. Alternatively, if someone comes to the United States undetected, somehow they can apply affirmatively for asylum, and that that means they don't have a notice to appear in immigration court. The process is different, and it happens at USCIS. At CAIR Coalition, we work exclusively with detained individuals, and everyone who is detained by ICE is in the defensive bucket. So that is what we are helping them with.
Okay, so there's a defensive where you are in court, kind of proving something or defending yourself, and then there's affirmative where you can go to USCIS. So is one or the other easier? Is affirmatively applying before DHS charges someone easier, or is it easier to do it defensively afterwards?
So I don't have that much experience with, or really any experience with affirmative applications. So I'm not entirely certain, but there are similar challenges for both. A person still has to show that they meet the requirements of asylum. And to do that, they have to present the same types of evidence. However, an affirmative application process allows the individual to apply directly with USCIS. And doing so, they're being interviewed by an officer rather than in the defensive context, they're in the court and they're being cross-examined. And that is how their story comes out. And the other thing that I'll just say on this is that if you apply affirmatively for asylum and it is denied, you get sort of a second bite of the apple and you get put into defensive proceedings in immigration court. So you can go before the judge again.
Defensive is kind of the step 2 of someone who's doing affirmative, but in the defensive case, it's all you can do.
Exactly.
Okay. So when people cross the border, do most people get to slide in and then do this affirmative step with USCIS?
Unfortunately, no. So there are sort of 3 options for somebody who comes through the border. The first option, I should say somebody who comes without a visa or some other legal way of entering. Okay. So the first is that they enter the United States somewhere along the border, not at a port of entry, and they go undetected. The second is that they try to do the first, but then they get pulled over by Customs and Border Patrol.
Okay.
And then The third option is that they say, hey, I'm at a port of entry and I am here to seek asylum. I'm being persecuted in my country. Of these three groups, only the people in category 1 would be able to apply affirmatively for asylum. The other two are, the second group will be put into what's called expedited removal proceedings, and will be removed quickly unless they express a fear and pass something that is called a credible fear interview, which we will talk about in a little while. And then the third group will be charged as inadmissible, but they can also have the credible fear interview, and assuming they pass, they will also be defensively applying for asylum.
So, but just to be clear, if I show up at an official port of entry and I, officially enter asking for asylum, I will be put into defensive. I won't be given the opportunity to do affirmative.
That's correct.
Oh, wow. Okay. Thank you for clarifying that. So let's start from there then, because we talked about, you just mentioned interviews and other things. So let's start from there. So I show up in the border, I ask for asylum. Am I detained? Am I released to family? Like, how does it begin?
So if we're talking pre-2019, things have changed in the past year, so, or year and a half. So we can sort of talk about post-2019 in a little bit, but pre-2019, okay. You approach the border, you get detained, and maybe you're transferred. Maybe you stay detained and you're transferred to a detention center in San Francisco or Maryland or Virginia or Chicago, or maybe you're released to a family member or paroled into the United States. So if somebody is picked up, either a person approaches the border and says, I'm here to seek asylum, or they're picked up within 100 miles of the border, and in their first 14 days in the United States, they are automatically in something called expedited removal. That means that they're going to be automatically deported without ever going to see a judge. The way we explain that in our Know Your Rights presentations in the jails is that we say it's like a train already moving, and the only way to stop it is to find an immigration person and express fear of return to your home country.
Okay.
And so once someone expresses fear of return, they will be scheduled for an interview about the fear to see if they really should go to court or not, and if they really have a claim or not.
Okay, so what is that interview called, that first preliminary interview?
That first interview is called a credible fear interview.
Okay, so is it only about if a person is credible?
No, although that is one of the things they're looking for.
Okay.
But they're also looking to see if the person is eligible for some defense to deportation. So not only do they have to be credible, but they also have to demonstrate that they are eligible for asylum or for protection under the Convention Against Torture.
Okay, so what are the requirements for asylum? To get into that a little.
So for asylum, someone has to prove that they are afraid to return to their home country because there's at least a 10% chance that they will be persecuted because of their race, religion, nationality, political opinion, or membership to a particular social group. So that's a little bit, that in a particular social group is in and of itself its own legal issue, but it could be something like they belong to a tribe or the LGBT community. Those are sort of common ones that we see in our practice. And they have to show that the reason why they're being persecuted is central to, that's central to their claim. So they need to show that they are being persecuted because of their race or because of one of the other things.
Okay, so let's say that, someone fears return because they were being recruited by a gang and they refused recruitment and the gang threatened them. Like, that doesn't have to do with my race or my religion.
So unless the gang was targeting them for one of those 5 reasons that I just listed, race, religion, nationality, political opinion, or particular social group, that they wouldn't qualify for asylum.
So are there other bars to asylum beyond just that being like a really narrow cap, beyond the fact that that's just like really narrow, that you have to prove that the person was persecuting you because of one of those 5 reasons? Are there other bars beyond that?
Yeah, there are other bars. So for instance, you have to apply, and there are some exceptions to some of the bars, which I'm not going to get into today, but
that's okay.
You have to apply for asylum within 1 year.
Okay.
of arriving in the United States. If you have certain criminal convictions, you're not going to qualify. If you have resettled in another country, so let's say you fled Ghana and you went to France and you were in France for 4 years, you're not going to be able to get asylum in the United States because the government can say, well, he was already resettled in France. And then there are other things like if you participated, if you were a terrorist or participated in certain things in your home country, you may also be barred from asylum.
Okay. So let's say, to go back to this gang recruitment example, let's say that I say in my credible fear interview that the gang was trying to recruit me and I refused recruitment, and I fail my interview because that's not one of the buckets that you listed, one of those 5 protected grounds. What happens if I fail my interview?
Well, 2 things. So first of all, the interviewer would also have to screen you for something called protection under the Convention Against Torture, which I mentioned briefly, and which we'll talk about a little bit later. So even if the persecution someone experienced doesn't fall into one of the 5 protected grounds, the interviewer asks a few additional questions to get a sense of if the person may be protected under the Convention Against Torture. And then afterwards, if a person still doesn't pass their credible fear interview, they can always request that a judge review it to see if the judge will agree with the interviewer's decision or overturn it. And I don't have the statistics on this in general, but we don't always see judges overturning the fear interview decision very frequently unless somebody has an attorney that can help them articulate how they would qualify in a way the interviewer may have missed.
Okay. So then what? So let's say I go to the judge, they do not overturn the decision. Then what happens?
If someone doesn't pass their credible fear interview, then the person is deported.
Okay. Okay. So let's talk about the flip side, the opposite. So let's say that I am being targeted because I'm Indigenous, which is both my race and I'm part of a tribe. So it's a particular social group as well. So I fit into 2 of the 5 buckets. And I have all this evidence and I pass my credible fear interview. So once I pass my credible fear interview, do I have asylum?
Unfortunately, no, that's just step 1. So then the next step is that that person will be referred to immigration court to begin what is called a removal proceeding to see if they truly qualify for asylum or if they should be deported.
Okay. And I guess, how does that work? So once I'm in court, what's the process?
Well, you've done a webinar called Inside Immigration Court, so I'll skip the details of what the courtroom is really like.
True.
But essentially, there's some number of preliminary hearings in which someone can ask for bond if they want, or they can, turn in their official application for asylum. And then once they've turned in that application and any evidence that they have, the judge will schedule them for what's called a merits hearing or an individual hearing, which is basically their trial.
Okay. And what does someone have to prepare for a trial?
So if someone can afford an attorney, or if someone gets placed with a CAIR coalition attorney, of course, it's up to the attorney to put all of that together and add legal arguments. But basically, you're showing any documentation you have that you were persecuted in the past. Maybe you filed a police report. If you have a copy of that police report, you would probably have a declaration explaining why you're afraid, what harm has happened to you in the past, and why you can't go back or you'll be persecuted again. There will be things like country conditions. Maybe it's very common in your country for your Indigenous group to be targeted. And so you would want the attorney, or you would want to show that, this is common practice. People know that this is happening and it's happening to me as well. So when an attorney puts that together in a brief, they'll also include legal arguments about why you should stay. And maybe, for instance, if we go back to the gang recruitment one, sometimes attorneys might make a political opinion. If you're saying, no, I don't want to be part of a gang, they might say that's a political opinion. So in truth, only about 14% of detained immigrants have an attorney. So 86% of the time, it's just the individual who's trying to assemble their own evidentiary filing with tabs from inside the jail and trying to figure out what the law is so they can explain how they're not subject to any bars and qualify, which is obviously very challenging, and it is very challenging to get the evidence when you're in a detained setting.
Yeah, I can't even imagine. So how long does that whole process take, from crossing the border, having the interview, you know, assuming that I pass the interview, having a few preliminary hearings, filing my application, getting my evidentiary filing together, and then having my trial and getting my decision? Like, to summarize everything,
Yeah.
outlines, like, how long does that take?
So it can depend, maybe 3 to 6 months, maybe a year. Also depends if there's an appeal that either you or the government can do if you win asylum and the government doesn't agree. But in the detained context, these cases move much more quickly, but it can still take a substantial amount of time. So it sort of just depends how, even we see in Virginia and Maryland, there are differences in how long somebody is waiting detained before they have these hearings.
Yeah, okay. So to go back, you mentioned earlier, so we've now talked about kind of this whole average process, the 5 buckets for asylum, and like the basic bars. But before this, you mentioned that this was all kind of in a pre-2019 context. So I guess, what are the main things that have changed since then? Like, what are the main things that have shaken this up in 2019 and 2020?
Sure. So immigration law is incredibly complicated and it's very dynamic. It changes every day sometimes. And so we might be on a jail visit explaining what is the law that day, and then the next day be like, the law changed. Now we have a whole different set of things to explain. And it really does change that quickly. But the main 2 things I'll talk about today are what's known as the Remain in Mexico policy and what is known as the third country transit ban, or the transit ban. Those have greatly impacted our work, certainly.
Okay, so let's take them one at a time. So the Remain in Mexico policy, I understand from the news, is like MPP, or the Migrant Protection Policy or Plan, but is like colloquially referred to as Remain in Mexico. Can you just, like, what is that? Can you explain what that is first?
Sure, and I think you'll probably talk a little bit more about this next week, but basically it applies to individuals who arrive at the southern border and ask for asylum, either at a port of entry or after crossing the border between ports of entry and getting picked up, and they're given notices to appear in immigration court, but they're sent back to Mexico to wait. They're instructed to return to a specific port of entry at a specific date and time for their court hearings.
Okay, but they're meant to stay in Mexico in the interim.
Yes. Usually instead of coming, they would come into the country either detained or not, and they would await their case here in the United States. Now they have to stay in Mexico for the entire duration of their asylum case, and that can take maybe 3 to 6 months, maybe to a year. I think Remain in Mexico cases might take longer than what we see in the detained docket, but I'm not sure exactly what that time frame is. It's kind of hard to know what exactly is going on.
Yeah, absolutely.
Another thing I just want to mention about that is that a lot of these people are coming from, maybe the Northern Triangle, which is El Salvador, Honduras, Guatemala, and they're fleeing gangs, and those gangs are also active in Mexico. And then in addition, there are other organizations that are taking advantage of people who are waiting on the border. So they may continue to be persecuted, or be persecuted in addition to the persecution they've already faced in their home country. Because of the Remain in Mexico policy. Okay. Exactly.
And then so the Remain in Mexico policy, and then what is the second thing that has kind of shaken this all up?
So the second thing is the transit ban. And this is a ban on asylum for any individual who enters the U.S. along the southern land border after transitioning through another country from leaving their home. So for example, if someone is fleeing an unsafe situation in Guatemala, but they're walking to the United States, they're going to have to walk through Mexico. And if that person doesn't seek asylum in Mexico and get denied in Mexico before they come to the United States, they're not eligible for asylum in the United States. It only applies to people on or who enter the US for the first time on or after July 16, 2019. It's been in effect for almost a year now, and there are a small number of exceptions to the ban. Like I mentioned, if you apply for asylum and you're in the country you transit through and you're denied, or if you're a victim of trafficking, but it has really drastically changed how accessible which asylum is for people, and it already wasn't very accessible.
Yeah, I mean, just hearing you talk about how narrow those 5 buckets are and kind of like what someone has to prove to get asylum, and then to think that anyone who walked here through another country is out. Although I do want to pause and just talk about what you said, that this only applies to the, quote, southern land border, end quote. I guess, so people who cross through the Mexico-US border. So if I'm fleeing from another part of the world, let's say I experienced something traumatic in like the Democratic Republic of the Congo, and I passed through, you know, however many countries and then flew and landed at Dulles Airport, that doesn't apply to me?
No. So anyone who shows up not via the southern land border, even if they've gone through 4 or 10 or 50 other countries on the way, this wouldn't apply to them. Now, they may have to show that they were not firmly resettled in any of those other countries, but this specific policy would not apply to them. And to be clear, this was not the norm before July 2019. And in many of our cases, or most of our cases, people are traveling through other countries that have similar conditions to their home country on their way here, making it even sort of bigger risk for them to try and apply along the way.
Okay.
So for example, if I'm fleeing Senegal because I'm gay and being gay is illegal in Senegal, but I have to pass through Mauritania, where there's actually the death penalty for homosexuals, it makes sense that I kept going. And I think there's definitely a similar situation with many of our clients from Central America, in which we have a client who's running from a gang that killed their family member in Guatemala, and just because they cross a border from Guatemala to Mexico, the gang's sphere of influence didn't end with the border. That gang is almost definitely active throughout Mexico too, with plenty of communication infrastructure to still target our clients. So this third country transit ban is new and different.
Okay. So you mentioned that there are like 2 exceptions to this rule. The rule being that I can't have asylum if I pass through, and the exceptions being that if I applied for asylum in every country I passed through and was denied each time, then I can still apply. And if I'm a victim of human trafficking, then I can still apply. But assuming that someone doesn't fall into those categories, you know, what recourse then, assuming that asylum is now off the table, right? Because I came from Honduras and like walked through Guatemala and Mexico to get here. Asylum is now off the table. What legal recourse is available for people who are, you know, afraid of returning, have fear for their lives upon return?
So a person in that situation can still apply for something called withholding of removal and for protection under the Convention Against Torture.
Okay. So can you tell me what the difference is between asylum and withholding of removal?
Sure. So withholding of removal has the same 5 protected grounds. So someone has to prove that they're being persecuted for the same reasons. But instead of a 10% chance of persecution, they have to show a 50% chance. It has to be more likely, or 51, more likely than not that it's going to happen, which is a much higher evidentiary burden. Okay.
And then what about for the protection under the Convention Against Torture?
So that is completely different. Instead of having to show you're being persecuted because of one of the 5 protected grounds, you have to prove that it's more likely than not that you will be tortured if you're deported, and that the government would know about it and either participate in your torture or not do anything to stop your torture.
Okay. So in my gang recruitment example from earlier, where I'm being recruited by a gang and I'm refusing recruitment and the gang is saying to me that they will kill me, maybe I might qualify for, even though that's not a protected ground. So I'm out for asylum and withholding, and I probably walked here, so I'm out for asylum anyway. Maybe I qualify for protection under the Convention Against Torture.
Yeah, it depends. Like, first you'd have to prove that the government knew about it. A lot of people don't have, they don't report to the police in their home country because the police and gangs might be somewhat intertwined. But if they didn't, it's much harder to meet your burden if you haven't reported to the police. Or if you reported, but of course you don't have documents showing that you reported because you just walked here from Guatemala, that also might be challenging to meet your burden. And you have to prove that it's more likely than not that you will be tortured upon return. That's really hard, and it requires a preponderance of the evidence, like maybe even a written or recorded threat from the people who are torturing you. Most of the time, people don't have that kind of evidence, especially after they've been walking miles and miles to get here. And I'll also add that for withholding of removal and protection under the Convention Against Torture, the one benefit of these is the judge can't use their discretion. In asylum, there's a discretionary piece. So even if you meet all of the requirements for asylum, the judge can still say, no, not today, not for you. But under withholding, for withholding of removal and protection under the Convention Against Torture, if someone meets their burden, that's it. There's no discretion. The judge has to grant their application.
So if it's not based on discretion at all, if the judge doesn't kind of like wield that ultimate power at the end, and it's only based on the facts, is it easier to get withholding and protection under the Convention Against Torture?
It's not, because the burden is higher. So someone has to prove that it's more likely than not that they'll be targeted. Whereas for asylum, you just have to show that it's a 10% chance possibility that you'll be targeted.
Okay. And I just want to emphasize something that you said about reporting to the police. So what I'm hearing is that for protection under the Convention Against Torture, someone has to demonstrate that the government is completely kind of like hands off about this, or
turning a blind eye.
Okay, like really knows about it. And so if someone didn't report to the police or can't prove that they reported to the police, is that like pretty much it's gonna like pretty much protection under the Convention Against Torture is like very unlikely at that point?
I think it would be a hard case to make without some type of physical evidence.
Okay. So for these last two, assuming that we're in this bucket, we walked through a third country to get here, so asylum's off the table, we're in withholding and protection under the Convention Against Torture territory, I get one of them. Is there a pathway to citizenship? Like, can I ultimately, after 10 years, 20 years, become a US citizen with those types of relief?
No. So if someone wins asylum, then they can first get a green card and then they can eventually get citizenship. But for withholding of removal or protection under the Convention Against Torture, that's really not an option. Actually, they're still at risk of deportation if the country conditions change. So like maybe a government eradicates the gang that was torturing a person, that would mean that the government could technically reopen the case and try to deport the person on those grounds. It's pretty rare that happens. I mean, I've never seen that. But it is still a risk that's associated with winning withholding or protection of the Convention Against Torture. And the other thing is you can't ever leave the second you step off of US soil with one of those protections, you're done. You can't come back legally. So
you can't travel with withholding or with protection under the Convention Against Torture?
You can't.
Oh, wow. Okay. So with all of this in mind, I kind of want to shift gears a little bit and talk about kind of like the work that CAIR Coalition does and how how CAIR Coalition is dealing with this. So we've just spent this time talking about how asylum is fairly narrow, and then because of stay in Mexico and because of the transit ban, it's even narrower. And then talking about how withholding and CAT, the Convention Against Torture, the burden is really high. I guess my question for you, Eleanor, I ran some numbers this morning about how CAIR Coalition has been dealing with this. My question for you is how many fear-based, so asylum, withholding, protection against torture, trials do you think that CAIR Coalition staff attorneys, or attorneys, staff attorneys, management attorneys, have won since we started working from home due to coronavirus?
Despite all of the legal complexities, CAIR Coalition has an astounding success rate.
That's true.
But I can't think, I have no idea. In the past 2 months, it's been really challenging. Maybe we've won like 10 cases.
Yeah, so I ran the report this morning, and since March 16th, CAIR Coalition has actually won 17 trials.
Wow.
Fear-based trials, yeah.
That's amazing. And that doesn't include bond wins or green card cases or anything else, just fear?
Yeah, that's just fear.
Oh, my colleagues are amazing.
Yeah. That's pretty cool. I just wanted to throw that in there.
Thank you for sharing that with me.
Sure. So Eleanor, thank you so much again for your time today, for explaining all of this. I know that so much of your job is going to jails and explaining this in both English and Spanish, so I hope that at least it was easier to explain it in English for the purposes of this webinar. I kind of want to wrap up by asking, you know, of all of the cases that you've worked on where someone was afraid of returning, you know, can you tell us a little bit about maybe like your one client where you just like still feel really good about that, or there was like a really positive outcome?
Yeah, I recently assisted a man who's from a country where he had a few reasons that he had been persecuted in the past and tortured in the past. One of which is that he is gay, and he was really not very comfortable. In fact, he was not comfortable at all talking about that. It took a lot of time talking to him to even get him to tell us that part of his story. But he was not eligible, unfortunately, for withholding of removal or for asylum. So he proceeded with CAT. And he won his case. He showed that it was more likely than not he'd be tortured. And now I actually just got news today, he was released from detention. So it's very exciting.
Oh, that's really incredible, especially considering how high that burden is and how we were just talking about how it's so hard without police reports and everything. That's really incredible. Congratulations.
Yeah. Thank you.
Okay, great. So I just want, you know, to wrap up by thanking you so much again for explaining all of that. So, you know, that person that you just described and 16 or 17 or 20 more are, you know, with relief and getting out of detention. And for anyone who's watching, you know, of course, if you have any questions, feel free to put them in the comments below, and Eleanor or another staff member can answer those questions. And of course, you know, if you're watching this and thinking, as I am, that this process just sounds incredibly difficult and incredibly hard to navigate without an attorney, and you want to support this work and support legal resources for immigrants who are detained by ICE, please consider joining 20 for 20. I'll go ahead and link it in the comments. But that's just like a really helpful and substantive way to support this work and support, you know, our immigrant neighbors in being sure that people have access to, you know, due process and the right to fight these things. And it's by contributing $20 a month to these legal and social services. So again, Eleanor, thank you so much. You are on the hook to answer all of the questions that come in the comments. So, you know, but I'm so grateful for your time. So thank you
so much for having me.